Article 120 Language to be used in Parliament. Clause 1 Notwithstanding anything in Part 17, but subject to the provisions of Article 348, business in Parliament shall be transacted in Hindi or in English, provided that Chairman of the Council of States or Speaker of this House of the People or persons acting as such as the case may permit any member who cannot adequately express himself in Hindi or in English to address the House in his mother tongue. Clause 2 Unless Parliament by law otherwise provides, this article shall, after the expiration of a period of 15 years from the commencement of this Constitution, have effect as if the words or in English were omitted therefrom. Article 121 Restriction on discussion in Parliament. No discussion shall take place in Parliament with respect to the conduct of any judge of the Supreme Court or of a High Court in the discharge of his duties except upon a motion for presenting or address to the President praying for the removal of the judge as hereinafter provided. Article 122 Courts not to inquire into proceedings of Parliament. Clause 1 The validity of any proceedings in Parliament shall not be called in question on the ground of any alleged irregularity of procedure. Clause 2 no officer or member of Parliament in whom powers are vested by or under this Constitution for regulating procedure or the conduct of business or for maintaining order in Parliament shall be subject to the jurisdiction of any court in respect of the exercise by him of those powers. Chapter 3 Legislative powers of the President. Article 123 Power of President to promulgate ordinances during recess of Parliament. Clause 1 If at any time, except when both houses of Parliament are in session, the President is satisfied that circumstances exist which render it necessary for him to take immediate action, he may promulgate such ordinance as the circumstances appear to him to require. Clause 2 An ordinance promulgated under this article shall have the same force and effect as an act of Parliament, but every such ordinance. Subclause A shall be laid before both houses of Parliament and shall cease to operate at the expiration of 6 weeks from the Assembly of Parliament, or if before the expiration of that period resolutions disapproving it are based by both houses upon the passing of the second of those resolutions, and subclause B may be withdrawn at any time by the President. Expiration where the Houses of Parliament are summoned to reassemble on different dates, the period of 6 weeks shall be reckoned from the later of those dates for the purposes of this clause. Clause 3 If and so far as an ordinance under this article makes any provisions which Parliament would not under this Constitution be competent to enact, it shall be void. Chapter 4 The Union Judiciary. Article 124 Establishment and Constitution of Supreme Court. Clause 1 There shall be a Supreme Court of India consisting of a Chief Justice of India, and until Parliament by law prescribes a larger number of not more than 7 other judges. Clause 2 Every judge of the Supreme Court shall be appointed by the President by warrant under his hand and seal on the recommendation of the National Judicial Appointments Commission referred to in Article 124A, and shall hold office until he attains the age of 65 years, provided that Subclause A judge may, by writing under his hand addressed to the President, resign his office. Subclause B a judge may be removed from his office in the manner provided in Clause 4. Article 2 sorry no article it's clause 2A. The age of a judge of the Supreme Court shall be determined by such authority and such manner as Parliament may by law provide. Clause 3 Clause 3. A person shall not be qualified for appointment as a judge of the Supreme Court unless he is citizen of India and subclause A has been for at least 5 years a judge of a high court or of two or more such courts in succession, or subclause B has been for at least 10 years an advocate of high court or of two or more such courts in succession, or subclause C is in the opinion of the president a distinguished jurist. Explanation 1. In this clause, High Court means a High Court which exercises or which at any time before the commencement of this Constitution exercised jurisdiction in any part of the territory of India. Explanation 2. In computing for the purpose of this clause the period during which a person has been an advocate, any period during which a person has held judicial office not inferior to that of a jurist judge, mm, inferior to that of a district judge after he became an advocate shall be included. Clause 4. A judge of the Supreme Court shall not be removed from his office except by an order of the President passed after an address by each House of Parliament, supported by a majority of a total membership of that House and by a majority of not less than two-thirds of the members of that House present and voting has been presented to the President in the same session for such removal on the ground of proved misbehavior or incapacity. Clause 5. Parliament may by law regulate the procedure for the presentation of an address and for the investigation and proof of the misbehavior or incapacity of a judge under Clause 4. Clause 6. Every person appointed to be a judge of the Supreme Court shall, before he enters upon his office, make and subscribe before the President or some person appointed in that behalf by him an oath or affirmation according to the form set out for the purpose in the third schedule. Clause 7. No person who has held office as a judge of the Supreme Court shall plead or act in any court or before any authority within the territory of India. Article 124A. National Judicial Appointments Commission. Clause 1. There shall be a commission to be known as the National Judicial Appointments Commission, consisting of the following, namely: Subclause A, the Chief Justice of India, chairperson ex officio. Subclause B, two other senior judges of the Supreme Court next to the Chief Justice of India, members ex officio. Subclause C, the Union Minister in charge of law and justice, member ex officio. Subclause D, two eminent persons to be nominated by the committee consisting of the Prime Minister, the Chief Justice of India, and the leader of opposition in the House of the People, or where there is no such leader of opposition, then the leader of single largest uh, opposition party in the House of the People members, provided that one of the eminent persons shall be nominated from amongst the persons belonging the scheduled caste, the scheduled tribes, other backward classes, minorities, or women. Provided further that an eminent person shall be nominated for a period of 3 years and shall not be eligible for renomination. Clause 2. No act or proceedings of the National Judicial Appointments Commission shall be questioned or be invalidated merely on the ground of the existence of any vacancy or defeat in the constitution of the Commission. Article 124b. Functions of commissions. It shall be the duty of the National Judicial Appointments Commission to: Clause A. Recommend person for appointment as Chief Justice of India, judges of the Supreme Court, Chief Justice of High Courts, and other judges of High Courts. Subclause B. Recommend transfer of Chief Justice and other judges of High Courts from one High Court to any other High Court. And subclause C. Ensure that the persons recommended is of ability and integrity. Article 124c. Power of Parliament to make law. Parliament may by law regulate the procedure for the appointment of Chief Justice of India and other judges of the Supreme Court and Chief Justice and other judges of High Courts, and empower the Commission to lay down by regulation the procedure for the discharge of its functions, the manner of selection of persons for appointment, and such other matters as may be considered necessary by it. Article 125 Salaries etc of judges. Clause 1. There shall be paid to the judges of Supreme Court such salaries as may be determined by Parliament by law and until provisions in that behalf is made is made such salaries as are specified in the second schedule. At clause 2, Clause 2. Every judge shall be entitled to such privileges and allowances and to such rights in respect of leave of absence and pension as may from time to time be determined by or under law made by Parliament and until so determined to such privileges, allowances and rights as are specified in the second schedule. Provided that neither the privileges nor the allowances of a judge nor his rights in respect of leave of absence or pensions shall be varied to his disadvantage after his appointment. Article 126. Appointment of acting Chief Justice. When the office of Chief Justice of India is vacant or when the Chief Justice is by reason of absence or otherwise unable to perform the duties of his office, the duties of the office shall be performed by such one of the other judges of the court as the President may appoint for the purpose. Article 127. Appointment of ad hoc judges. Article 127. Appointment of ad hoc judges. Clause 1. If at any time there should not be a quorum of the judges of the Supreme Court available to hold or continue any session of the court, the National Judicial Appointments Commission, on a reference made to it by the Chief Justice of India, may with the previous consent of the President and after consultation with the Chief Justice of the High Court concerned request in writing the attendance at the sittings of the court as an ad hoc judge for such a period as may be necessary of a judge of a High Court duly qualified for appointment as judge of the Supreme Court to the designation by the Chief Justice of India. Clause 2. It shall be the duty of the judge who has been so designated in priority to other duties of his office to attend the sittings of the Supreme Court at the time and for the period for which his attendance is required. And while so attending, he shall have all the jurisdiction powers and privileges and shall discharge the duties of a judge of the Supreme Court. Article 128. Attendance of retired judges at sittings of the Supreme Court. Notwithstanding anything in this chapter, the National Judicial Appointments Commission (NJC) may at any time, with the previous consent of the President, request any person who has held the office of a judge of the Supreme Court or of the Federal Court or who has held the office of a judge of a High Court and is duly qualified for appointment as a judge of the Supreme Court to sit and act as a judge of a Supreme Court, and every such person so requested shall while so sitting and acting be entitled to such allowances as the President may by order determine and have all jurisdiction powers and privileges of but shall not otherwise be deemed to be a judge of that court. Provided that nothing in this article shall be deemed to require any such persons as aforesaid to sit and act as a judge of that court unless he consents so to do. Article 129. Supreme Court to be a court of record. The Supreme Court shall be a court of record and shall have all the powers of such a court, including the power to punish for contempt of itself. Article 130. Seat of Supreme Court. The Supreme Court shall sit in Delhi or in such other place or places as the Chief Justice of India may, with the approval of the President, from time to time appoint. Article 131. Original jurisdiction of the Supreme Court. Subject to the provisions of this Constitution, the Supreme Court shall, to the exclusion of any other court, have original jurisdiction in any disputes. Clause A. Between the Government of India and one or more states or Clause B, between the Government of India and any state or states on one side and one or more other states on the other, or Clause C, between two or more states, if and in so far as the dispute involves any question whether of law or fact on which the existence or extent of a legal right depends, provide that said jurisdiction shall not extend to a dispute arising out of any treaty, agreement, covenant, engagement, sanad, or other similar instrument which, having been entered into or executed before the commencement of this constitution, continuous in operations after such commencement, or which provides that the said jurisdiction shall not extend to such a disputes. Article 131A, exclusive jurisdiction of the Supreme Court in regard to the question as to constitutional validity of central laws. That was the omitted by the Constitution 43rd Amendment Act 1977.